Hello, everyone. I'm Andrew Beaudry. Welcome to Your Bread and Butter podcast.
And I'm Ryan Cummings. Today's episode is legal documents. They're not just for dead people. We're going to discuss the importance of legal documents, to have them now while you're alive, and what are some of the big ones to think about for everyone's estate plan.
You know, lawyers really do take the fun out of everything. Did you know that? Yeah, because even with Santa, there's a clause.
See you soon.
Discussions in this show should not be construed as specific recommendations or investment advice. Always consult with your investment professional before making important investment decisions. Securities offered through Cambridge Investment Research Incorporated, a registered broker-dealer. Member FINRA SIPC. Advisory services through Cambridge Investment Research Advisors Incorporated, a registered investment advisor. Cambridge and Private Financial Design LLC are not affiliated.
Bread and butter.
Hello, everyone. Welcome back. Today, we're going to be talking about why legal documents aren't just for dead people. It's because legal documents really are meant for the living, for the people that you care about, including yourself, for your care and well-being. But really, they are in the present. And so it's not just at death when legal documents are very important. And I know from my own experience in dealing with this with clients, we've had episodes and instances where people needed health care, but because there was no health care proxy, the family couldn't really make those decisions, though they tried. And because there was medical interference into what the family wanted, it ended up being a very bad situation. As well, we had situations before where a durable power of attorney was needed to work on a spouse's account, and the spouse that was sick and not able to, make decisions on anything, the spouse was not able to work with her husband's account until we could actually come up with a durable power of attorney that they did have, even though it was antiquated. So this is a very important topic for all of us who are alive.
Yeah, there's a lot of, I think, misconceptions that people have about the importance of an estate plan. I think people give so many excuses to push something like this off. I think a good comparison is that, like a gym membership. You know why a will or an estate plan is a lot like a gym membership?
Let's work it out.
It's close, what? But everyone knows they need one, but they'll put off every excuse they can to start it. And so a will, a trust, power of attorney, health proxy, it's not a fun conversation. People have all sorts of excuses like, well, I'm not all that wealthy, or, I'm too young, or I don't have a family yet, or I'll just get to it later. All these different reasons that people want to avoid it because it is an uncomfortable conversation to start, but it can help avoid an even more uncomfortable conversation in the future if you have a proper estate plan.
Well, that's why we're filming this here for January, and that's why I got the Bruins jersey on. Bruins are rocking it. Come on. But anyway, this is really a big deal only for one reason. If you don't have it, you can't use it. So you got to have it. Mm-hmm. So if you don't use it, you lose it. And on that note, when people are talking about the awkwardness of all of this, nobody really likes to talk about dying. Nobody really likes to talk about what it's like being sick. But those are real things that happen. So that's why we're here today to talk about this. Now, on that note as well, why is it that estate attorneys are really, the most determined professionals out there?
I don't know why.
And it's because where there's a will, there's a way.
Speaking of a will, that is one of the key documents in starting an estate plan.
It is.
To not confuse it with a living will, we're talking primarily a last will and testament. So we'll get more into that in a second, but some of those key documents include that last will and testament, a durable power of attorney that we've already alluded to, a health proxy. Those three are almost something that just about anyone's going to need, regardless of whether you're that super wealthy person, you have a very basic estate, you have a family, or you don't. These are things that, as we'll go into more detail, that almost anyone should have. And then also proper designations, beneficiaries, TOD, POD designations. We'll dive more into all these things today. And then even there are trusts that come into place, but we're not going to get too much into those. That's an own separate episode.
It's a separate episode.
But with these at least basic ones, these are some of the documents we're going to cover that, like I said, almost everyone should have.
And we're not lawyers. Ryan and I, we can give you a little bit of guidance, but you've got to go to your lawyer. An estate planning lawyer is usually best. Somebody that deals with real estate transactions might have some knowledge in this area, and usually they do, because it does involve probate courts at times. But I do think a real live estate planning attorney is where you're going to get your best legal advice, because we can't give you legal advice, but we can tell you just some general knowledge. And remember, these documents preserve your choices and protect your loved ones when you can't speak for yourself, and even could protect you. So today we're going to talk a little bit about this idea of what is a will or a last testament. And a will is a legal document that states what happens to your assets when you die and who's responsible for carrying out those wishes. But the idea about this goes way back to ancient Rome. In Rome, the process was called testamentum. Wills, serious business, even back 2,000, 3,000 years ago, and they had to be witnessed by 6 or 7 people who would then seal the document. And when the person died, those same seals were broken in front of witnesses in an early version of what we call probate.
Exactly. That's kind of where it came from originally. And then you fast forward, a few thousand years to 1066 AD. After the Norman conquest, England started developing a system that moved away from the church and feudal kings having absolute control over the land. And that shift helped shape some of the inheritance rules that we still use today. And so then here's where the word probate comes from. It traces back to the Latin probare, meaning to test, prove, or examine. So by 1463, probate in English literally meant the official proving of a will.
Now, this is important to understand that, the probate process has such a long history. I mean, in 1463, you're talking about, 600 years later, we're we're in that mode where we use it all in our country. We use it over in Europe. These are all very affirmative. So probate court today literally means confirming that a will is legally valid, and once approved, it becomes an instrument by which the executor, who's been assigned to oversee the estate, can enforce and handle it. So in short, your will states your intentions, and the probate court is the process that proves it and puts it into action. That's your quick history. So now, why everyone else needs a will, and let's talk about the probate process and how it works.
To put it in layman's terms, the probate process is a series of court proceedings. Right? Whenever anyone passes, you'll see a little bit on this graphic here, there's a series of steps that these courts go through in each state to help distribute your assets to your heirs, to your next of kin. Now, if you have a will, that can help make that process quicker, more streamlined. If you don't, well, the court's going to have their own set of rules. We'll go over those in a minute, especially for Massachusetts, on where different things go. But as far as the probate process, you can see it's going to begin with paying off creditors, notifying creditors that you've passed, and making sure that they're aware of your passing and the process of the probate courts have started. Then the executors guide distribution of assets to your heirs as well as your creditors, because some creditors will have to be paid off with those assets and others may not. It all depends on the debt. For example, a federal student loan is discharged at your passing. It's not something that the federal government's going to come at as a creditor that needs to be paid. Whereas something like a remaining mortgage on a home, well, that's a different story. The bank's not going to just let that mortgage go and let the house, go to your heirs. It's going to have to be paid if someone wants to keep that property in your estate. Lastly, as we get into the last couple steps, and you can see petitions for personal representative may need to be filed. And then not every state has to go through probate, and that's actually a big part of an estate planning process, is to potentially try to avoid the probate process if at all possible. And that's because, probate, it takes time. We're talking days, weeks, months, or even years if there's contention in your estate. And then it also costs money, anywhere in the 2 to 7% range of your estate. And so a lot of people, their goal is to save their heirs both that time and that money by avoiding as much probate as possible.
Now, if you're ever wondering about how these things get known and talks about, things get published. So it has been the trend over the last 85 years where these probating processes get published in the local newspapers. So I don't know what they're going to do in the future about this. I'm sure they'll create some sort of website or some sort of notification process, but they normally put it in the newspaper. So you can look in the newspaper, usually once a week they have these listings inside the classified ads for the probating process going through. So I don't know what the future holds on that, but if you ever want to know, hey, what happened to somebody's estate, you can do it that way. So first, let's talk about creditors.
Creditors are first notified. Legal notices have to be published that anyone that's owed money within the estate has a chance to come forward and claim their share if they're entitled to it. And then next, there's the executor. They're named in the will. And I've had some pretty funny conversations with some clients in the past of saying, I was named the executor of my parents' estate or this person's estate or that. And it's kind of funny. Some people that maybe don't have knowledge of that position, think of it as this, maybe they're going to get something from the estate by being named the executor. Well, the executor is actually just a job. It's actually work. You're being tasked with actually having to attend court and do all these processes. You're actually not entitled to anything from the estate as the executor. You're the person that's there to guide on when and how assets are distributed, how to make sure creditors are paid, how to make sure the right heirs receive their assets in a timely manner, filing tax returns if needed for the estate. Those sorts of things.
Sounds a little onerous, but just to make sure people know that, if you have to fly to San Juan, Puerto Rico to take care of something in somebody's estate, the estate will pay for that. It's not like it has to come out of your pocket, but this is not a profit position.
Right. And then if you are someone who is the executor, but also inheriting from the estate, well, that is kind of coming out of your pocket in that scenario because, that's less money you may inherit if probate costs go up. So when you're naming an executor of your estate, it's a lot of times makes sense to name someone somewhat local. That way there's less travel costs to attend these probate hearings.
And if there's no executor named in your estate, is what we call dying intestate. And particularly here in Massachusetts, one needs to be officially appointed. So there's a petition for a personal representative that's filed, and the court issues a letter of administration called letters of testamentary. So these documents prove that the appointed administrator has legal authority. And in Massachusetts, this all happens through the Massachusetts Probate and Family Court, which handles everything from wills, estates, trusts, to divorce, custody, adoption, guardianship, and much more.
It does. And so when you're looking at each state's rules, not every state's a little bit different. And like we said earlier, we want to try to avoid probate as much as possible to streamline a lot of this process that we're discussing. If you can make assets, instead of having to go through these court proceedings, if you can make assets go directly to your loved ones, and that's, for example, we're talking beneficiary designations, so on things like IRAs, 401ks, life insurance policies. If these sorts of accounts have beneficiaries, that's a clear sign of an asset that can go directly to that heir and avoid the probate process. Now, in terms of accounts that don't have those sort of designations, if we're talking like an investment account, cash accounts, etc., well, that's where TOD or POD the designations.
So when you have a bank account and let's say your spouse has died or you don't have anybody really that is around you other than, maybe a child that lives in a distance away or maybe in a local town, you can make that person payable at death, or POD. So you pass away, then it automatically transfers to them. You could also make it a TOD on your investment accounts, which is transfer on death. What that means is whatever investments you have, that passes to that beneficiary at your death. Now, the one thing about the transfer on death for investments is, let's say you are single on an account, you have $100,000 that you put in originally, and then it's grown to $300,000. You pass away. Your daughter is on that account, or your son's on that account, or all your children around, and you got 5 of them. So all 5 of them inherit that account, filling out their forms as beneficiaries, but they get a step up in basis to the $300,000 value at your date of death. This avoids the probate. It avoids taxation. There might be some small taxes that are due based on the date of death to when the actual transfer occurs, and if you sell the assets off. But transfer on death is a really clean way to, or payable on death is a really clean way to pass assets along without having to worry about going through the probate court.
It is. And so that's where, having all these designations as well as a will, so everything's laid out clearly where things are going, is important, because the common misconception I think that a lot of people fall into, especially married couples, I think are the key demographic that fall into this misconception, is that, well, I'm not maybe overly wealthy, my estate's not complicated, I'm married, everything just goes to my spouse, right? And you can see actually on this chart, this one's specific to Massachusetts, that's actually not necessarily the case. Because if you don't have a will, you don't have beneficiary designations, you don't have TOD, POD, none of that, then the probate court, the state in this case, they're going to have their own set of rules, their own guidelines on where assets go.
And here we go. We got children. You have children.
But no spouse.
The children get everything. Okay? Spouse, but no descendants or parents. Spouse gets everything. Then the spouse and all of the descendants are from you and that spouse, and the spouse has no other decedent. So the spouse inherits the first $100,000 plus half of the balance, and descendants inherit one half of your intestate property. So it doesn't just go to all, where you think it's going to go.
Right. So that's what you can see in both of these kind of middle ones here, whether it's you're married, but you have descendants, both parents, kids, descendants on both spouses' sides. You can see it starts to get where not everything goes to your spouse anymore. Things can actually go to parents, go to children, etc. And that's where we start to get things that get a little more complicated as far as the split. So if you want to make sure you're not just leaving this up to the state's law, well, that's where all these documents play an important role. And then we get back down to the last few where you have a spouse and parents, but no other descendants. Your spouse inherits first $200,000 and 3/4 of what's left, but then your parents get the rest, that last 1/4 above the $200,000. So there's all these moving parts. And then
if you don't like your in-laws, you're not going to like that one.
Right. And then you have parents, but no spouse or other descendants. Siblings inherit everything after your parents get that first $200,000 and then the 3/4 of the balance. So, again, there's all these different dynamics, all these different structures. Don't leave it up to the state, I think, is the simple takeaway.
The rule of thumb is, have a will.
Right.
Don't wait. Just get it done. Don't worry about it. It'll all work out. Now, the next one is probably the most important document for a married couple. This gives each spouse the ability to maneuver financially, to work as a durable power of attorney for them. It does end at the spouse's death or another person's death that it's on. But the durable power of attorney is a key part of this process, because it gives the ability for each spouse to be able to work and take care of the other one on a legal basis. So if you have spouses that each have investment accounts, and one spouse, is becoming ill, like I said earlier in an example, the wife or the husband can't call on the other spouses and do anything on that account unless they have a power of attorney.
Right.
Because if it's solely in that other spouse's name, they can't intervene. So even though we all know each other and all that, the law says no. You might be married, but you don't have legal authority over his or her account. So getting a durable power of attorney makes that work.
Yeah, and that's, I think, another one of those common misconceptions. I think we hear it all the time of people like, well, I'm married. Can't my spouse just call up and access my accounts? Well, if they're not a joint owner, like you said, or if they're not a power of attorney, the answer is no, they cannot. So instead of having to go through and make every account joint, if you don't already have it, well, that's where just adding a power of attorney can be the kind of stopgap for something like that. But it doesn't always have to be a spouse either. It allows you to name anyone as this agent or attorney, in fact, to handle your financial matters as banking, bill pay, taxes, contracts, investments, etc. And you can name them as a immediate power of attorney, or what's referred to as a springing power of attorney. Immediate would, as the name implies, give that person immediate access right now, as soon as that document's signed, access to all your finances, banks, bill pay, taxes, etc. Springing would only allow that person to have this sort of control if something happens to you, you're incapacitated, you're still living, but you're unable to make any of your own financial decisions. So that's where you can add that distinction. For example, I'll even use my own case. My wife and I are each other's immediate power of attorney. And then we each named a sibling as our backup, but the siblings are only springing power of attorney. So my wife and I have immediate power for accessing each other's finances. Instead of adding each other to all of our accounts, it was a much easier option. And then we named that backup that only has power in the event that either of us, or actually in this case, it would be both of us, are technically incapacitated to put that second in line in power, essentially.
Yep, agreed. And then again, it's just a simple fact that terminates at death. A durable power of attorney is only valid during a lifetime. And so once you pass away, its authority ends and your will or your executor or a trustee in some cases would take over. So that's the simple basic guidelines of a durable power of attorney. And again, it doesn't have to be your spouse, doesn't have to be a sibling, but it better be somebody that you trust. And you might want the springing feature, but it all depends on what is your need. So talk with your attorney about it, get good legal advice. Now, the next ones are important too. Now, that's why this is for living people. We're going to talk a little bit about healthcare proxy and a living will.
So a health proxy, very similar to a power of attorney, except instead of your finances, it's your medical decisions. So again, in the event, the common theme here is in the event that you're unable to make your own decisions of your own sound mind and body, you're incapacitated in some manner, well, this healthcare agent, healthcare proxy, is the person that can make those decisions for you. Now, again, misconception time here. A lot of people think that if I'm married, my spouse has that power. That's not the case. I'll give you a quick example of a scenario where a husband and wife, they had discussed their wishes, the husband and wife both, if anything ever happened to them, didn't want to be kept on life support. They wanted to, maybe have a reasonable means of, trying to save their lives, but not be kept long-term on a life support method. I think that's something a lot of people share as far as their wishes. Well, unfortunately, something happened to the husband. He was incapacitated in the hospital, being kept on life support. They tried all reasonable measures, and the wife, essentially said, well, hey, we had this discussion, talked about it with the doctor, and this is what he would like. Well, the husband's parents stepped in and came in and said, well, no, we don't want that. We want him to continue to be kept on life support just in case things change. He turns around. Well, even though the wife they're married legally, that was now held up in court. They actually had to go to court proceedings, and the court ruled that they kept the husband on life support. And that was because that was a reversible option, whereas the latter, or the former, was a irreversible option.
Right.
And so they went against the wife and husband's wishes and ultimately followed what the parents wanted, because that was the option that could, eventually be changed, and at least to give more reasonable time. So point being is, if you want one person to have that final say, that's where the healthcare proxy is key. You give that person this power to make those decisions. Work with the doctor, give them direction on consent or different treatments. Because it's not always just about life support too.
Right,
it's about, well, what treatments do you want? What medications do you want to take?
And all of it has to be documented. It's got to be in writing.
Right.
And the incapacity springs up, sort of like a springing effect here again, becomes effective only if you're incapacitated and it gets invoked. I did have a situation where I had healthcare proxy over an aunt, and we had she was in her 90s, in 93, and she had clearly communicated to me, do not resuscitate me the next time I go into cardiac arrest. So, and that had happened. So, I went, gave everything to the people that were there at the facility, and gave them a DNR that she had already agreed to years ago. And I get a call while I'm on a trip somewhere that, hey, your aunt had an episode, but we were able to bring her back, and da-da-da-da. I'm like, that's not what she wanted at all.
Right.
So I had to, when I got back home, sat down with her, and at that point she was really incapacitated, just barely able to do anything, and just squeezed my hand to say, no, don't let this happen again, like she wanted to go. So anyway, you have to make sure, and you say, well, they even had the DNR and they didn't follow the orders. Well, next time they did. So that time they followed the orders. But if you got it in writing, that's how it works. Now, the living will is a very interesting proposition. So let's talk about that.
Yeah, when you're saying if you have it in writing, I mean, that's where the living will comes in. Because while the healthcare proxy is a person that makes the decisions, your living will is your document to let your own voice be heard ahead of time, right? If you can't talk, you're incapacitated, you can't let your wishes be known, well, you can create a living will and list out what you want done in these different scenarios. Do you want to donate organs? Do you want to be kept on hydration or nutrition, and for how long? For what sort of efforts do you want done ahead of time? Now, I think the key thing with a living will is while it is this whole list, it can be this guideline in all these scenarios. One, it can't cover everything. So it's still good to have a health proxy as your, overarching deciding factor there. But two, your living will actually is also not the deciding factor. If you have a living will and a health proxy, your health proxy overrides the living will. You can think of the living will as more just like a guideline in this scenario, but it's still a good thing to have, because what if you didn't have every conversation like this with your health proxy? They now have this list, this guideline to follow in these sorts of scenarios.
In whatever state you're in, make sure you get with an attorney that understands how this works, because you can do the healthcare proxy in some states that is conjoined with the living will. Some states are going to require it to be separate. But either way, make sure you get good legal advice from your attorneys to make sure that it's happening the way you would want it to happen. So let's talk up and sum up these final thoughts.
Yep. So with these documents, to sum them up, it's the will being the last will and testament, your healthcare proxy, power of attorney, living will, and then those designations, POD, TOD, beneficiaries. Make sure you're reviewing these things and establishing them if you don't have them. And if you're someone who does have them, every 5-ish or so years, it's a good idea to re-review them. Make sure nothing's changed. Now, if nothing's changed, you take a quick look at it. Maybe everything's in order, and you wait a few more years.
And you got to plan while you can. I mean, you're alive, you're breathing, you're watching this show. So you got to do it. Legal documents are about giving power to the quality of life and to what you've worked hard for in your life, and protecting those you love. It's nothing really to be fearful of. Yes, the end results of being ill and the end results of dying can be fearful, but these are tools for living well, not just dying well. So encourage yourself. Look in the mirror and say, I'm going to get this done. That's why we're doing this in January, because it's the beginning of the year. Exactly. So everybody's making their resolutions. Well, talk to your family. Review your beneficiary designations. Meet with a legal professional to get in writing your needs and wishes and wants. Yes,
I think the last point I'll mention there is just yes, it's an uncomfortable conversation. Yes, it's something a lot of people like to put off, but it's can be what is likely a one-time, uncomfortable conversation to make an even more uncomfortable situation, being, unfortunately, if you were to pass, making that situation significantly easier by having this, slightly uncomfortable conversation ahead of time.
Yeah. And just remember, legal documents aren't just for dead people. And if you found this helpful, share it with someone who's been putting off their planning. It might be you in the mirror, who knows? And remember, the best time to plan is before you need to.
It is.
That's important.
Definitely.
Thank you for listening today. And remember, live today for the tomorrow that's in your heart.
Because you'll never have more time to plan for tomorrow than you do today.
Thank you for listening.
Bread and butter.